parents have died because the parents have a life interest. And the good thing with the life interest is that when you have a life interest, the parents, they can sell, they can borrow money without permission from the children. Because the children, we call the
Parents have
children in a
died, but the
situation like
parents have
that
a life
remain the men.
interest.
I'm getting an echo on the line now. We call them remainder men, and so the children will not get an interest until the life tenant have died, the remainder men. So, but in a situation like that, the parents don't have to make a will for that property, because even if they will the property to somebody else, the other persons can't get it, because when the parents died, the remainder men will get the property. Also, you can be like when persons buy property, the common one is joint tenancy. So persons are joint tenants, and a lot of times lawyers take it for granted that people should be joint tenants because they are married. But no, your tenancy should match your situation. So people can be joint tenants or you can be tenants in common. When two persons are or joint tenants or three or whatever the number are joint tenants and the tenancy is written on the title. So Mr. and Mrs. Brown are joint tenants. That means when Mrs. Brown dies, Mr. Brown will get the property. Or if Mr. Brown dies first, Mrs. Brown will get the property. So when it comes to joint tenancy, the survivor will get it. So when you're making your will for the joint tenancy, the will should say, if my wife should die before me, I give the property to. And the husband's will should, and the wife's will should say, if my husband should die before me, I give the property to. And the property will fall in the will of the one who died last. The other option is tenants in common. So, for example, two persons are buying property and you don't want the other one to get your share if you should pass. For example, two strangers come together in a business situation buying a property. You don't want to be joint tenants where if one dies, the other one get it. Each will want to leave something for their children. Or brothers and sisters buying property, and each of them, they have your own family. You're going to want to be tenants in common so you can will your share. So it's important for you to discuss your tenancy with your lawyer before when you're buying property, and don't let the lawyer make that choice for you. Your situation should make the choice. This is Land Matters on Caldwell Gospel Radio. And I want to look at a few of the questions asked. My mom has 1 acre of land which she got by will. And the surveyor was saying I could survey that 1 acre. Yes, I'm suggesting that as well. So in a situation where everybody has put their house on a little piece of the land, I always say to the clients, sometimes persons will come and say, we want one big title because we live good. Sometimes this generation is living good and the other one isn't, the one to come. And I always feel that that 2 titles better than one. So in a situation like that, you're on the piece of family land, you have your little piece, or maybe you bought that little piece, survey your little piece and let us assist you in getting a title. So I agree with the survey. In a situation like this, mom was build 1 acre. You know where the 1 acre is. If you don't know where the 1 acre is, and there was nothing specific about it and it wasn't pointed out to mom, it's the executor or the person who administers the estate who is to determine how the land is to be shared. The executor or the administrator, that person is in charge. And that person is to determine how the land is to be shared. So in a situation like that, it is the executor's responsibility. So I would say, yes, tell your mom to go ahead and survey her 1 acre and then move to get it titled. What if someone builds on your land without permission, was not contributed to any upkeep of the land, has not contributed to any upkeep of the land, refused to pay the peppercorn lease, and now wants me to pay to come off the property? Do I pay? The question is, how long has that person been on the land? Because if the person pays the peppercorn lease, they can't claim it, but if they don't pay it, they can claim. So that is the situation, which is why we say make sure persons are paying when they are on your land, regardless of what. Don't tell them to pay the tax because they are there. Let them pay you even $1 a year, and you give them a receipt and give them a notice to come off if it's not working out, and then go to court to get the person off. But if the person stays there and keeps stringing you along and 12 years pass, you're going to have to pay them to come off because it's whatever they're on is going to belong to them. That is if they are there without permission for 12 years. Another question, what are some of the things that are considered in subdivision? I'm thinking of subdividing where I live. Someone says it must have two gates. Not necessarily, and most times no. Because the thing is with subdivision is that the local authority, we call them the municipal corporation now, we used to call them the parish council. Most time you're doing a subdivision, they want one entrance. They don't want everybody driving onto the main road. So you will hear they say that the entrance is to be grouped. So there's nothing to say about any two gate, etc. But let the surveyor advise you how the subdivision surveyors, the commission land surveyors are experts in determining how the subdivision should be done. That is where you should really be, that's what you should be talking to get a commission land surveyor. And please make sure that the person you get to survey your land is commissioned. We all have smartphones now. Just put in land surveyors in Jamaica and you'll get a list of all the surveyors. Make sure the person you are using is on the list. So when you're going to subdivide your land, a number of things they will take into consideration. Location is important because you might be subdividing a piece of land in Kingston or St. Andrew or Portmore or in one of the towns where they will allow you to have a square for a lot. But if it's in the country, you might hear that we're not going to allow any lot less than quarter acre because the aim is that country persons are not to live too near to each other because you need to have a little piece of land at the back that you can farm, etc. So it's going to depend on the location that is taken into consideration when subdivided. Also, you need to look at the conditions on the title because the title might say the land is not to be subdivided. So those are the things taken into consideration. But the surveyor is your first point of contact when you are looking to do a subdivision. They are the ones who will guide you as to how it is to be laid out. But the two gate thing, don't make that decision about any two gates unless the surveyor tells you that you need a two gate solution, because that might not be so. And I thank the persons who have sent their feedback to say that the programs have been very informative because we know that knowledge is power and we want to empower our listeners so that they will have the knowledge. The aim of a program like this is, I always say, to create village lawyers. So persons in the communities can have knowledge, know-how. So when you see persons doing things the wrong way, then you can always be there to guide. So this person wanted to know about tenants in common. Okay, so if they have so yes, so tenants in common can be fractions. That's one of the good things about it. So I'm buying a property with my husband and he's putting up most of the money and he might say, I want to have a bigger share. That's the option you have with tenants in common. So he could get 3/4 and I can get a quarter, or I could get 2/3 and he get 1/3, or I can get 9/10 and he can get 1/10. So that it can work like that. You can put any fraction. You can even give me 1,000th of a share and you will have 999 thousandths of a share. So you can, if the tenants in common gives you the option to determine the share that persons can get. And I was talking earlier about the parish council in terms of cutting up land. But note that if you have had your little piece of land, even though the land there's a big parcel of land on the tax paper, and you just have a little piece, if you can show that you have been on your little piece for more than 7 years, we can get a waiver of the subdivision. So you can show, I have an old diagram to show that I surveyed my little piece a long time, or my mother had a whole old diagram when she gave me my piece, or I have documents to show that I have been on this little piece because I have a deed of gift, or I have the receipt when I bought it, and the receipt or the deed of gift is more than 7 years. We can help you to get a title. We can help you to get the subdivision waived, so you can get a title for your property. So it's not lost. And remember that in a situation like that, the size wouldn't matter. So even if you're on quarter of a square and you can show you are there for more than 7 years and there's nothing on the title to say it's not to be cut up, I can help you to get a title. And if you want assistance in getting a title, just send me the word, just WhatsApp the word title to me. WhatsApp it to 876, WhatsApp the word title to 876 387 3183. That's my WhatsApp number, 876 387-3183. Just send me a WhatsApp message with the word title. That's all you have to say. Title, and I will gladly assist you in getting a title for your property. But please remember, if you have any question for me this evening, just send a WhatsApp message to 876-868-5109, 876-868-5109, or 876-535-8186, 876-535-8186 for any question or query you may have. You're listening to Land Matters on Called Gospel Radio, and the aim of this radio station is to empower, educate, and inform our listeners. Called Out Gospel Radio is located in Ocho Rios, Jamaica, and the aim of the station is to impact lives positively. And we welcome all of you joining us on Land Matters. My name is Gloria Brtown. I'm an attorney in Jamaica with an office in Ocho Rios, St. Anne. That's in the Jamaica National Building in the heart of Ocho Rios, that blue and yellow building in the heart of Ocho Rios in St. Anne. And I also have an office in the Winchester Business Center in Kingston. You may also contact me at 876-387-3183, 876-387-3183. What is your advice about adding my children to my title? It depends on your situation. As I said earlier in the program, if you want to add your children, and maybe anybody you want to add to your title, the first thing I ask my clients, the persons you want to add, are they contributing to the National Housing Trust? Because if persons are contributing to the National Housing Trust and you put their names on the title, the NHT might say they own property already, so they can't get a full benefit. That's something you have to consider with your children. So sometimes when persons come in to add, I might encourage them to maybe make a will in a situation like that. Or I might say to them, do the life tenancy, as I said before. Take a life interest in the property. So the title will read to John Brown for life and after death to the children, and you put the children on the title. Because in a situation like that now, when you have put the children on the title, then and they don't have, and you have a life interest, housing trust can't say they own property because they will not own any property until you have died. So that's an option that we need to consider. And you can put as many children as you want on the title. There's no limit. You can put 1 million people. Just as how there's no size limit, as I always say to the clients, if the surveyor will survey it, no matter how little it is, how small it is, I will title it. There's no limit to the size that you, when you're putting on persons onto your title. I want to welcome persons who are listening on the different means to Called Out Gospel Radio on this Land Matters. And indeed, land really matters. And I want to encourage my listeners, as I always do, to make a will. And you will always find me stressing that on this program, because that's one of the things that I preach. Make a will. Even the Bible speaks of it, okay, of the testament. Make a will. We are living a lot of confusion, a lot of problems, okay, and a lot of uncertainty, because a lot of times why we have so much conflict is that our expectations and reality don't coincide. Because my mother said that before she died, that the house is mine because I'm the one who looked after her, I'm the one who paid for her funeral and everything. But Mama did not make a will. So because she did not make a will, the property belongs to all of her children, even though she said by word of mouth that it is mine. Word of mouth cannot pass property. Write it down. So even though she said the property is mine and everybody heard her say it, or my brothers and sisters heard her say it, okay, there's a saying we used to use in the country that word of mouth can't go a law. Okay? We can't come and say Mama said it was mine. Mama needs to write a will. And a lot of times I hear people come into the office, especially women, and they might say, but my husband told me that nobody can take me off of the land. Don't let anybody tell you that, please. Let them write it down. Okay? Because dead men tell no tales. Don't let people tell you that, oh, nobody can take away the house from you. I've seen it so many times when, especially when people are not blood related. People have looked after older people, care for them for years, and they die and the relatives come in. And when the persons come into the office and say, but I look after him, and he said that the house was going to be mine and he died and the relatives come and throw me out. He never made a will. And you are not a blood relative, so you can't put in a claim. So don't let anybody tell you that this is yours, that is yours, and nobody can trouble you and nobody can move you. Don't take those things in 2025. Let persons write down what they are going to give you. Because as I said, expectation, you expect to get the house, but the reality is you are not a blood relative. So the persons have, because when a person dies, you have next of kin. Children come first, spouse come first, then you have children, parents, grandparents, brothers and sisters, uncles and aunts. All of those persons going to have priority over you. Who just the person who look after the old person, carry them to clinic, bury them, stay up with them at night, carry them to doctor, to hospital to visit. The only thing you might end up with is blessings. So don't let people tell you that this is going to be yours. Let them write it down. Let them make wills, not a letter or anything, but a will, which must be a written document witnessed by two persons and the person who is making the will. And remember, if the person who is making the will cannot write, the person can make an X or somebody can sign for the person. And you can always buy a will form. The will forms are easy to use. They are user friendly. When you look at them at the heading, you see where you must name the executors. The last will and testament of John Brown. I appoint Mary Brown and Peter John as my executor. And remember, the executors are the person who are going to make sure that everything in the will is carried out. The executors can do anything that the person who died could do. So executors can sell the property because the owner could sell. Executors going to collect the money in the bank, the NHC contribution refund, the insurance money, all of those monies will go to the executor. So it is very important that you think about who your executor should be. And it's important that you choose persons who you can rely on, people who are reliable to be your executor. That is extremely important. Choose your executor very, very carefully because executors are powerful people. And also remember that executors are entitled to 6% of your estate. So executors must share in the estate. They are to get 6%. So you have a house valued 5 million, executors are to get $300,000. And executors have the right to sell. So I always say to my clients, the best executors are your beneficiaries, the persons you are going to leave the property to, the persons you are willing the property to. Make them your executors if they are responsible enough, because sometimes, or if they are old enough, because your executors must be over 18. And sometimes your beneficiaries are your young children. So you don't want to leave them in that rut. You don't want to leave your children, you can't make your children executors. And you don't want to leave them in a rut where you don't make a will. Because if you have young children and you don't make a will, then the administrator general is in charge of the estate. And that department is overburdened. They have too much work to do because too many Jamaicans are dying, leaving young children or young next of kin. And in situations like those, when they have these young ones, then they don't make a will. The administrator general has to take over. And that office, as I said, they just have too much work. We're leaving them with too much work. Make your wills. You're listening to Called Out Gospel Radio, and you're listening to the program called Land Matters, aired every Tuesday at 7:30 p.m. Called Out Gospel Radio is located in Ocho Rios, Jamaica, and the aim of the station is to educate and to impact the lives of persons positively. And welcome to all who are joining us via the radio stream, on the app in the Google Play Store, or on the YouTube channel. And remember, we have other programs that I've aired on different topics, and you can just go onto the YouTube channel and look at Called Gospel Radio Land Matters. And the program is just for half an hour. And remember, you can send your text messages to your WhatsApp messages to 876-868-5109. Okay, okay, and or 876-535-8186. And Dev is asking, when the will is written and the landowner is still alive, where is it kept? Who gets it? That's for the landowner to decide. When I make wills, I always make 4 copies, at least 4. I give the persons 3 and I keep 1. A lot of times the clients will say, I don't want anybody to know I have this will. So I usually say to them, just say to your relatives, if anything should happen to me, go to Gloria Brtown attorney, because I will always have a copy. And as well, you can find a trusted person, maybe your pastor, a colleague, a JP, your brother, your sister, your children who you make the will for. But a lot of time we don't want people to know what's in our will, and we must know why. But you can also record the will at the Island Records Office. That's another option as well. So it's all up to you. But let somebody know you have a will so they don't go through the process of administering your estate to say you die without a will when there is a will, because the beneficiaries might be different when you administer from whoever you have named in your will. So let somebody know there is one. I've seen so many persons calling from abroad asking me if I can locate their parents' will. And and that's something that's partially impossible for you to do, because you don't know where the parents would have put it, whether it's under the mattress or it's in the Bible, or pastor has it or the lawyer has it. And I find a lot of people don't know who their parents' lawyers are. It's important for you to say to the client, my lawyer is Gloria Brtown, or whoever your lawyer is, with an office in Ocho Rios, in Kingston, wherever she is. So if anything should happen, and make sure your lawyer, if you have a lawyer, the lawyer has a copy of your will. It is extremely important. And your will is something you should be updating regularly. You have got more assets, or you made a will and you will the house, but you have sold the house and bought another one, or you have sold the house and you don't have, or you have bought a house since. Whenever your circumstances change, always change your will, update your will. It's extremely important for you to do that. Or if anybody in your will should die, executor, beneficiary, witness, make over your will. Always keep your will current. You have made a will, but you have had a child since. You need to make over the will to make provision for this new child. Or you're pregnant, you can make provision for the child you're pregnant with, child who is in the womb. But sometimes I've seen where wills are old, wills are outdated, persons die, and then if you had got a chance, you would really have done over that will. And another thing, please make the wills and stop making excuses for your parents. I see so many persons making excuses. My mother died suddenly, so she never. That's always it. We die suddenly, so we don't make a will. As long as we reach 18, we need to develop that will culture. As long as you reach 18, you might say you don't have anything. But sometimes we have things and we don't even know. Because God forbid, and a person is in an accident, then whatever monies would come to the person if the person died, it's going to go to the estate. So we need to just have these wills written, as even for young children on over 18. As soon as you reach 18, I leave all I have, or I leave all my earthly possession, I leave all my possession to my parents. And then you can keep changing it when you get a house or you get a job. You might not have anything, but I leave my car, I leave my NHT contribution refund to my parents. And as your circumstances improve, then so should your will. But it's very important. Are children privy to will while the parents are alive? How does will work? A will speaks from death. So the will only takes effect when the parents have died. So you can't see your parents' will and start jumping up and down and say the house is mine and the parents are still alive, because they can change the will at any time. And in terms of the children being privy to the will, if you mean privy in terms of having knowledge of it, then that's for the parents to decide. You might say, I have confidence in my children, I'm going to send the will. And a lot of clients will say that I want 3 copies because I want to give each of my children one. So it's for the parents to decide how much information they want to give the children, if any. But the children cannot claim anything until the parents have died and the will has been probated. Okay, because a will only speaks from death, because you can change your will every morning and every evening. Just as how okay, you are free. We have freedom of testamentary disposition. You don't even have to leave anything for your children. Okay, so we are free to do that. And I'll continue on that a little later. Thanks for the questions. And you have been listening to Colo Gospel Radio Land Matters. I thank you so much for continuing to support this radio station and this particular program. Look forward to sharing again with you next week, Tuesday, God willing, on Land Matters. Have a good evening, everyone.
That we can. Oh, oh, oh. The soul of the innocent is crying out. Our Father is giving up. He's plagued by doubt. A mother has shed her last tear. Her heart caged by so much fear. She's crying, oh, 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 oh. Oh, oh, oh. Heavenly Father, heal our land. Heavenly Father, stretch forth your mighty hand. Show us how to care for our brother. Show us how to love our neighbor. And like a candle, let's shine your light to let our children know that we care. We offer this prayer to you, for we know that you will come through. Put your hand on us, bless us again, touch us again. Put your hand on us, touch us again, bless us again. But we have